So now we will be going to discuss what is the family law today and how best we can teach it in the class. As the family laws cover an enormous area of domestic relation, such as marriage, matrimonial rights, obligations, matrimonial remedies, maintenance, legitimacy of children, custody, guardianship, adoption, joint family, intestate and testamentary succession. It is a very important and wide law. The long list of topics and multiplicity of diverse family laws, some of which are codified, while others are uncodified, makes it not only very vast area of study, but also one that governs an integral part of the life of an individual. So, the first thing which the teacher has to keep in mind while teaching the family law is to explain the applicability of various family laws to various persons in the society, in the community. Let's start with these various laws. Suppose a teacher is teaching Hindu law. What he has to taught, first of all, what he has to tell to the class is that this is the statute which is applicable to Hindus for matters relating to marriage, divorce, maintenance, adoption, minority, guardianship, succession, etc., etc. After telling that these are the statutes, the teacher must tell them what was the law prior to the enactment of those statutes. Because as far as Hindu law is concerned, it has been enacted in 1955 and 1956 in 4 statutes. Prior to that, Hindu law was uncodified and there was unlimited number of customary practices or shastric provisions which were applicable to Hindus, Buddhist, Sikh and Jain living in India, depending on the caste they belong to, the religion they belong to, the community they belong to, the place they are living in, the school by which they are governed by like Hindu law, it was divided into 2 schools, Mitakshara law and Dayabhag law. Dayabhag law prevailed in eastern part of India, while Mitakshara law is applicable to rest of India. Mitakshara law was further subdivided into 4 sub-schools: Mithila school, Banaras school, Bombay school and Dravidian school. And the provisions of these laws in matters relating to family law differ from each other. So, before the enactment of these 4 statutes in 1955-56, which are the Hindu Marriage Act, Hindu Adoption and Maintenance Act, Hindu Minority and Guardianship Act, and Hindu Succession Act, there were unlimited number of laws which were applicable to Hindus, and it was recognized by the court. Like, as per the Shastric law, there was no concept of divorce, dissolution of marriage among the Hindus. But in certain communities, Hindu communities, divorce by customary practices was recognized. So even prior to the commencement of the Hindu Marriage Act, which specifically make a provision for judicial divorce, the divorce which were given or taken prior to 1955 were protected if there was a proof of customary practices prevalent in that community or caste or subcaste or community for dissolving the marriage by that procedure. that customary law of divorce has been protected by the Hindu Marriage Act by Section 29. So even today, a Hindu marriage can be dissolved either under Section 13 of the Hindu Marriage Act, which specified various grounds for divorce, including the mutual consent ground, and it can also be divorced by following the customary practices prevalent in that particular community to which the two persons belong, the husband and the wife belong, which permit dissolution of that marriage. So, prior to the Hindu Marriage Act, in matters relating to marriage, matrimonial rights, matrimonial reliefs, etc., the Hindus are now governed by the Hindu Marriage Act of 1955. This act is named Hindu Marriage Act of 1955, but if we look at the application of the act and the provisions of the act it contains, we can say that calling it Hindu Marriage Act is a misnomer. The act is not applicable just to Hindus, but it is applicable to a person who is Hindu by religion, who is Buddhist by religion, who is Jain by religion, who is Sikh by religion. Meaning thereby, these four statutes, the Hindu Marriage Act, Hindu Adoption and Maintenance Act, Hindu Succession Act, and Hindu Minority and Guardianship Act, these statutes are applicable to all persons who are follower of the four indigenous religion, and the act also says that it applies to any other person who is not a Muslim, Christian, Parsi or Jew. So such wide is the application of the Hindu Marriage Act. Secondly, if we see the provision on the Hindu Marriage Act, we can say that none of its provision is in compliance with, or you can say is recognizing the Hindu law prevalent prior to its enactment. The provisions of this act is the modified law, the codified law, modernized law relating to marriage and matrimonial matters. You will not find corresponding provisions or corresponding customary practices prior to the commencement of this act. Take the example of number of spouses. Hindu law permitted unlimited polygamy for Hindu male. Though polyandry, Hindu women having more than one husband was not permitted except in some tribal areas. But polygamy was permitted, a man having more than one wife at the same time. And it was not even limited to 2 or 3 or 4. A Hindu male could have any number of spouses, wives, prior to the commencement of this act. This act, the very first condition of marriage specified, given in section 5 of this act, says that neither party has a spouse living at the time of marriage. Meaning thereby, a totally new law has been made for Indians. There was no concept of dissolution of marriage in Hindu law. This act has made all the marriages dissoluble by a decree of divorce from the court of law on proof of the specified grounds given under the act. So, as such, this law is not Hindu law of marriage. It is law of marriage which is applicable to Hindu, and Hindu means followers of any of the four Indian originated religion, indigenous religion. Friends, as a teacher of family law, we have to explain all these things to our students. This act has changed the law of marriage and matrimonial relations totally. But it is not that these changes have been made in the vacuum. The legislature of that time felt the need to change the Hindu law. And that is why they have amended and codified Hindu law and modernized it as per the requirements of the time. So, when we discuss this act, we have to discuss the provisions of this act word by word. Like when we discuss the number of spouses a Hindu can have according to this act, neither party has a spouse living at the time of marriage. It is just half a sentence, but interpretation of it, analysis of it, each and every word of this half sentence has to be discussed in the class so that the student will come to know when can we say that the marriage is in violation of this mandatory clause. There are 4 more conditions of marriage stipulated in section 4. 2 of them were there from the very beginning. Even in the Shastric law it was there that 2 sapindas cannot marry, and the persons falling within the degrees of prohibited relationship cannot marry. And there are social and biological reasons behind prohibition of such marriages. Of course, the degree of sapinda relationship for prohibition for marriage has been reduced by the statute. The act require or specify the age for marriage when a person will become of marriageable age, and it also requires that the parties to the marriage must be of sound mind at the time of marriage, or must not be of unsound mind or not suffering from mental illness or mental incapacity. The marriages are divided into 3 categories: void marriage, voidable marriage, and valid marriage. But before determining whether a marriage is a valid marriage, void marriage, or voidable marriage, the first thing which has to be determined is whether it is a marriage or not. And that we have to determine as by applying section 7, that whether the marriage has been solemnized by performing the customary rites and ceremonies applicable to either party to the marriage. If such mandatory ceremonies are not solemnized, it will be a case of no marriage. It will not result in a relation of husband and wife. Children will not be legitimate, and none of the right or obligation of matrimonial relation will arise out of such a marriage. If the marriage is properly solemnized as per the law, then we have to see whether it is valid or not. For that, we have to see section 11 and section 12. If the marriage is in violation of clause 1, that is, it is a bigamous marriage, or it is solemnized between the persons who fall within prohibited degrees or who falls within sapinda relationship, then the marriage is void. If it is not in violation of any of these 3 clauses, then it can either be a valid marriage or a voidable marriage. Voidable marriage subsists till it is annulled by a decree of the court, and on the decree of the court, on the annulment decree of the court of that marriage, then it will become non-existent from the very day of solemnization. Section 12 deals with that and had specified 4 grounds on which a marriage can be declared to be annulled, declared to be on which a marriage is voidable and can be annulled. And the most important of these ground is if the consent of the parties has been taken by force or fraud as to a material fact or circumstance concerning the respondent. As far as this is concerned, we have to keep in mind that Hindu law does not require, the codified Hindu law does not require that the consent of the parties to the marriage is essential for solemnization of marriage. But if the consent of a party to the marriage has been obtained by force or fraud as to the nature of ceremony or as to any material fact concerning the other party, then it can be annulled by a decree of the court. If we look at the Muslim law of marriage, divorce, adoption, succession, inheritance, whole of it, including maintenance and guardianship, is uncodified till date in India. Muslim law is uncodified and it is the Shariat law deriving from Quran or from Hadith which is applicable to Muslims. The Muslim Personal Law Shariat Application and Act 1937 makes a provision for that Muslims, all Muslim, whether they are born Muslim or they are convert Muslim, they will be governed by the Muslim personal law only and not by any other customary practices which they used to follow prior to their conversion. Muslim law permits polygamy to a Muslim man, that a Muslim man can have up to 4 wives. What is the reason behind this permission? While discussing the law of polygamy in Islam, we must discuss those conditions also. Muslim law from the very beginning permits extrajudicial dissolution of a Muslim marriage. Why that permission was there in Islam, that also we have to discuss before discussing Muslim law of divorce. Similarly, as far as the Christian law, Parsi law and law of the Jews is concerned, Christian law and Parsi law is now, Christian and Parsi family law is now fully codified. Christian law is codified in Christian Marriage Act and Indian Divorce Act. Indian Divorce Act of 1869 and Christian Marriage Act of 1872. Indian Divorce Act on the demands of the Christian was amended in 2000, and by 2000 amendment it has been modernized, and nowadays almost the provisions of all these statutes as far as matrimonial reliefs are concerned are almost the same. Difference here and there only. Along with these religion-based, religion-specific laws, we have Special Marriage Act, and in that act, any person belonging to any religion, it may be an inter-religion marriage, inter-religious or intra-religious marriage, can be solemnized under that act, and once it is solemnized, that marriage will be governed by that law, Special Marriage Act, and not by any other law. Thank you.